the same panel from last time, and then Laura Tamez, Jennifer Doan, and then Mike Tankersley from the Texas Business Law Foundation. Let me do this. Let me ask Lee to go first, and then Laura, and then Mike, and then Jennifer, if that's okay. Lee, go ahead.
Thank you. Good morning. Lee Parsley again on behalf of Texans for Lawsuit Reform. I appreciate the invitation to be here today and to visit with you about specialty courts. I'm going to be on a different kind of specialty court than our prior panel.
Yes.
Elon Musk offered $44 billion to buy Twitter not long ago. Then he decided he wasn't as excited about Twitter as he used to be, so he tried to back out of the deal. That is now in litigation in a business court in Delaware. Delaware has become the place where people incorporate, and they incorporate in Delaware for two reasons. One, the substantive law of Delaware, the statutes and the case law of Delaware is good. It provides good guidelines for companies to operate, and it has for decades, and that's why one reason companies incorporate in Delaware. We in Texas have done a pretty good job of duplicating that substantive law into Texas law. We, for years now have created LLCs and limited liability partnerships and LLPs and all kinds of things that duplicate what Delaware does in terms of its substantive law. But where Delaware still has us beat is they have a judicial system that then deals with its substantive law in a way that corporations and other kinds of entities understand, in a way they can rely on. They know they're going to get predictable outcomes and pretty quickly. That case with Elon Musk, $44 billion at stake, is moving rapidly through the Delaware court system. It has a judge, and she knows what she's doing, and she is moving the case along, and the shareholders of Twitter are going to know fairly soon whether that bid for $44 billion is good or bad, whether Elon Musk must honor it or not. And that's the advantage of a business court. You see it in play in Delaware today. We have, as you just heard, there are 204 specialty courts they were just talking about in Texas. We are, in fact, specialized from the top of our pyramid to the bottom. We are one of two states in the nation that has specialty high courts. We have a Court of Criminal Appeals and a Supreme Court. They're specialty courts. We have specialty courts to the very bottom of our pyramid. There are municipal courts that hear only small misdemeanor cases and decide whether you spend the night in jail or get out on bond. And we have JP courts and courts of county courts of law and district courts. And among the district courts, we have family courts and criminal courts and juvenile courts and civil courts. And I probably couldn't even list all the specialty courts we have in Texas. We are specialized. The one specialty court we don't have is a business specialty court. In the last legislative session, Representative Landgraf filed and worked toward passage of House Bill 1875, can't even read my own handwriting, which was a specialty courts bill. It provided that Texas would have a court system that would hear shareholder derivative actions and lawsuits between businesses fighting about business issues, not personal injury cases, not family law cases. There was a long list, again, of exemptions of things that it wouldn't hear, but it's those cases that are two businesses fighting over a pretty good chunk of money. And we think that that's a great idea. We think Representative Landgraf had a good idea and a good bill, and we think that the legislature should, again, consider that in the upcoming session as a good economic development tool in Texas to bring more corporations to incorporate here, to do their business from Texas, because they know that they have a court system in Texas that is reliable and that is quick and is going to apply the laws uniformly over time. One of the great things they do in these specialty courts around the nation, the 29 states now have some form of specialty court, either a pilot program or a full-blown specialty business court. Not just specialty courts, specialty business courts in 29 states. We're behind the curve, which I almost never say to this legislature. We're behind the curve on a civil justice issue on business courts because they're an economic development tool. They invite businesses to come to your state and to conduct business. And I'll be happy to answer questions, Mr. Chairman.
All right, thank you, Lee. Let's get through the panel, and then members, we can ask questions. So, Laura, let me go to you next.
Sure. Mr. Chairman, committee members, my name is Laura Tamez, and I'm President-elect of Texas Trial Lawyers Association. Thank you for allowing me to be here today on this issue of creating special business or chancery courts in Texas. We've heard from a fantastic panel just a minute ago, especially Judge Phillips, who indicated that the mission and purpose of specialty courts is to be transformational for individuals as opposed to being remedy-based. However, while there is not a specific piece of legislation before us at the moment, I do want to address some of the proposals in the past. I know that in the past, even last session, there was a fourth iteration of a letter that was provided to this committee in March of 2021, uniting TADC, TTLA, and Texabota against the proposal of special business courts. I want to also share that TTLA is committed to working with this committee toward a balanced and impartial administration of justice and delivery of justice. So since that time of March of 2021, there hasn't been a study or an analysis that is showing evidence of a demonstrable need for these business dispute courts in excess of $10 million. There hasn't been outrage that there's a backlog of these courts or of these cases in our Texas district courts, or that there's been a miscarriage of justice somehow. We have heard that 29 other states are doing it, but we haven't seen any data correlating a boost in economy of those states to, again, demonstrate evidence of a need. So a couple of issues: creating a completely separate trial and appellate court system that has concurrent jurisdiction with our Texas district courts. There would be a concern as to how those judges would be selected or appointed. As members, as these members, the committee members know, back in 2020, the Bipartisan Texas Commission on Judicial Selection was created after assessment and 14 hearings of invited and public testimony. They came to a recommendation on the, at least against the adoption of a nonpartisan judicial selection system. We applaud their work and we stand with their findings. They did interestingly recommend, which some of the past legislation has proposed, increasing the qualifications of our judges, and which TTLA has always been a proponent of. And again, interestingly, that constitutional amendment was on the ballot in 2021, and as the committee members are aware, by way of Senate Joint Resolution 47, Proposition 4 passed, where Texas voters had the desire to increase qualification of judges, both at the district level and then, of course, the appellate and Supreme Court justices being 10 years. So that the legislation that is addressed having more qualified judges has been addressed, and the Texas voters have spoken. Finally, again, as the members of this committee knows, if there is a Texas court that has to deal with specialized or complex litigation, especially in business disputes and other types of cases, Chapter 74 of the Government Code allows for additional resources to be provided to those courts, to include an associate judge be assigned, to include more advanced technology, perhaps specialized CLE and training, so that those courts can manage and try these specialized cases in Texas. So again, we look forward to working with the committee. We're always here as a resource. Thank you so much.
Thank you. Thank you, Laura. Mike.
Thank you, Chairman Leach, Vice Chair Davis, and members of the committee. I'm Mike Tankersley. I'm here on behalf of the Texas Business Law Foundation, an organization I helped found 30 years ago. I've served as its chairman twice, most recently just prior to the last session. And over that time, I think my first discussion with Chief Justice Tom Phillips about business courts around 2002. And his advice was to speak to the chief judges in Dallas and Houston about them. I spoke to the chief judges there. They said basically they're a great idea. A business court would be a great idea. However, my judges would revolt if I told them that they were no longer going to get the flow of these cases for a number of reasons. And the idea died. It was picked back up by Representative Villalba in 2015. He introduced a concept of a chancery court for Texas in 2015. The bill that was most recently discussed in 2021 bears no resemblance to that first bill. It has nothing to do with chancery courts. And if somebody wants to argue against Texas chancery courts, they're talking about 2015, not 2021. The example that Mr. Parsley provided of the Delaware Court of Chancery is a very interesting and powerful but narrow example. What we're proposing is that Texas join the 25 other states that have business courts that we compete with for bringing business to Texas. These courts in, in New York, for instance, has had a business court for over 25 years. It's very developed. It's widely recognized, and it brings business and litigation to the state of New York. If you're in part of a company and you get a Chamber of Commerce presentation of why your company should go to New York, you get a video, a 15-minute video that starts with the chief judge of the New York court system telling you about their business courts. Then you have the general counsels and the CEOs of some of the biggest companies in the U.S. saying, we really appreciate our business court. And you also get Steve Sussman, may he rest in peace, as part of their Chamber of Commerce video bragging on the New York's business courts. It's for a reason, because it's not that they're smarter up there. I think we'd all agree that New York lawyers are not smarter than Texas lawyers or Texas judges. The reason that you just get an efficiency effect when people handle a similar type of case. And also that efficiency flows also down to benefit the average citizen. The average citizen will never be in front of a business court. These are $1 million and up kind of issues of people in their professional capacities. But what you do get is when a big case, and I believe the trial lawyers here, I'm not a trial lawyer, I've always been a business lawyer, but when you've got kind of a medium-sized case in a civil court in Texas, and you see coming up for docket call lawyers from 5 law firms, got 20 lawyers, 14 paralegals, and evidence experts up there, you know that your case, which needs to just have this one motion heard, is going to get pushed aside for a while. Potentially months, sometimes years, and so those cases can clog up a general jurisdiction court. Whereas if you kind of move them over, the courts get expert in handling them, and things move along faster. The last bill that was proposed, 1875, was one that we supported. It's just starting in the direction of proposing a business court. The business court idea and how the judges selected are kind of separate discussions. I would say our observation has been there's not much of a Democrat-Republican divide on these kinds of cases. And having just a single body of law for your state that everybody is more or less part of is very helpful, because most of these cases had lawyers charging clients to advise them on how to structure their transactions. If you have a Texas party and an out-of-state party right now, the standard advice coming from Texas business law firms is choose the law of any other state but Texas for disputes under this. And the lawyers for the other side, where they're from other states, they come in, they say, we don't want to litigate in Texas, and they'll walk away from deals sometimes to avoid that problem. We want to be a good state for business, and we want to be a good state for business to litigate their issues among themselves, and so that's why we ask that you consider putting a business court into the discussion here in Texas.
All right, thank you, Jennifer. Y'all are going to have some questions, so we'll circle back around after you.
Sure. Chairman Leach and the rest of the committee. Again, I'm Jennifer Doan. I'm president of the Texas chapters, the American Board of Trial Advocates. I think it's important that we reiterate what we stand for Texas Vote here. One is to protect and preserve the right to trial by jury, which is directly being attacked by the business courts bill that is being, as proposed last year, in which we believe, and from the evidence so far in this committee has heard, probably will be an iteration of that being proposed again next year. The second is to support the independence of the judiciary, and the third is to uphold the rule of law. With respect to the specialty courts and the whole panel that we heard just before our panel, those specialty courts dealt with county by county, specialty courts that are set up. They don't abrogate the right to trial by jury. In fact, they do have the right to trial by jury, and they're done with the courts in that county. Even the family courts are the courts in that county. If there are family courts, if the county supports the need for separate family court judges, they are elected to hear cases in that county. So what's being proposed in this panel by the Mr. Tankersley and Mr. Parsons are a business courts that are not county by county, but that are a business court set up for the entire state for certain businesses. And we don't have the data, and this has come up a number of years, and as you know, I think we've written Representative Leach and this entire committee on behalf of Texabota, TTLA, and TADC for a number of years. The data has not been shown that a specialty business court, separate and apart from the 254 counties in Texas, to be appointed by the governor to hear certain matters is not warranted. We don't have this overflow of business cases that are being set, and so it looks like there are certain backlogs in certain counties. I hear what Mr. Tankersley said with respect to if you went in for a hearing or a docket call, then the court, that really might clog the court. Well, I know we're all run county by county, but I can assure you if you're somewhere in far west Texas or far east Texas, that the big town lawyers take a backseat to certain issues that can come really quickly before that court, and then the court will dedicate the rest of the time of the day for something that's a larger issue. But there's not been any data that supports yet that, oh, hey, these business court cases are really clogging up Dallas County courts or Harris County courts or Bexar County courts. And so therefore, we need a separate business court, a specialty court for that county to handle these business courts. I think it's really imperative to hear the irony in the issue of, yes, we do want to be good businesses, a state with draws good businesses, and we are. Look what happened during the pandemic. Look who all has moved here. And no one has said that we don't have good jurisdictions and good courts to hear these business matters. And the irony of TTLA and the Texabota testifying before this committee, they're representing the plaintiff lawyers. We're representing plaintiff and defense lawyers saying, we don't want a separate one court system just for businesses. Most plaintiff lawyers, if they're going to bring courts in that state, they're going to tell this committee, hey, we really need, our cases aren't being moved forward here. But we're not taking that position here. The data doesn't support it. When you look at what Mr. Parsons said at the beginning with respect to Elon Musk, I'm not speaking for Mr. Musk, but I doubt he would sit here before this committee and say, I can't believe I was sued in Chancery Court in Delaware. Wish I could have been sued in a business court in Texas. I would think that would help the economy here. That's not what he has said. So we don't have any testimony supporting anything like that. Just a few more points with respect to this issue with respect to business courts. It's a major overhaul of what is being proposed last year in the piece of legislation, 2 years before that, 4 years before that, 6 years before that. There's no crisis or need that's being called out for that yet. And to restructure courts to add a business courts assumes that if I'm a sitting judge, whether I'm in Bowie County or Amarillo or El Paso, and there is a local business interest that comes before me, maybe it's a lot of dollars because it deals with a lot of widgets, but it's a simple issue. Or maybe it's a lot of dollars because it deals with energy, which are usually all large dollar cases, that somehow they don't have the gray matter or the education to hear those issues or the experience. When I know there are certain young judges in certain counties in Texas, but you look at the overwhelming vast 254 counties in Texas, very experienced trial lawyers sitting in those courts that have had experience in business court matters, as well as personal injury, as well as family issues and other things. There's nothing to support that they do not have the intelligence to handle those matters. And we look at the differences between Delaware and Texas. I don't know that any Texas trial lawyer would say that we want the same court system that Delaware has. They have the chancery courts. We don't. I mean, by law, they're combined with law and chancery here. They don't necessarily have a right to trial by jury in all civil cases. Because of the chancery cases, you would not have a right to trial by jury. We do here in Texas. We have a right to trial by jury. It's a constitutionally provided right. We want that right. We have a constitutionally, well, there's argument whether it's constitutionally provided right, whether they have elected judges, but that's what we have in Texas. And Delaware does not have all elected judges. So there's a massive differences between where we are and where Delaware is. I know all those have been outlined in the letters that this committee has received. I mean, Delaware as a whole, the numbers might have changed during the pandemic, but as of the letter from March 2021, there was still not a community yet that had over 100,000 in population. Only 3 counties, the 6th least populated county in our nation. We're the 2nd largest populated. We're the 2nd largest period. It's a really large county with a lot of different things. We have lots of different specialty courts, which, as this committee has just heard, some of which we applaud loudly. But the way the business courts bills have been presented in the past, what we anticipate will be presented in the future, we look at to see just more study needs to be done to see if that is the type of specialty court, since we're phrasing them all to be specialty courts, that we really need here in Texas.
Mr. Chairman, can I?
Yeah, absolutely.
Can I just make clear? I don't know where the idea comes from that the specialty court proposal last session, or that anything TLR would ever offer, does away with the right to a trial.
So that was my first question, Lee. I'm here reading the bill. I'm looking at the committee sub right now, and I'd also like you to remind me, Lee, what was different from the committee sub and the original filed bill last session. But can you answer that question? And Laura, maybe you could jump in as well. How, in any way, shape, or form, this would subvert the right to a trial by jury?
Well, the reason that came out is because his first comment was the Delaware Chancery Court that he was proposing. Wouldn't it be great if we had a Texas business court? We don't have a bill before us right now. One might not have been last year, but the right to trial by jury in a Chancery Court, you don't have.
Well, I just want to be absolutely clear. We are not proposing doing away with the right to trial by jury, and neither did the House bill last session. It's in the Texas Constitution. We're not proposing that. We wouldn't support it. It's not what I'm saying to you.
I was merely responding to his very first.
Yeah, and I don't want to get into a debate here. I am glad you clarified that for us, Lee. I was attempting to. I'm reading the bill here as we go. I know the committee has some questions, but before we get to that, can you remind me, Lee, or maybe Mike, you can, what the difference was, what changes we made in the committee substitute last session? If you don't remember, that's fine. I can.
They were very minor. There was a big change between the 2019 bill and the 2021 bill in terms of condensing the size of the cases that it would hear.
Mike, the commercial court in New York, let's take that for example. How do they select their judges in New York?
Well, the judicial selection process for judges in New York is quite different here. I think they have basically an appointive, recall kind of a system, but I'm not an expert in it. I could be saying that wrong, but I mean, their judges they take a pool of judges that are existing like in say Manhattan, and then they pick individual judges who have been selected by the standard New York process who apply to become a commercial court judge. And then they are considered by the administrative leaders of that court, and then selected, and then they are assigned a docket that is the specified business court docket for that area.
Okay.
But the statute really preserves trial by jury very expressly every time we put it out. And the other thing is that this bill and the Delaware Chancery Court are apples and hand grenades. I mean, you just can't even start to compare the two, because the cases that go to the Delaware Chancery Court would not come to this court, and the cases that would come to this court would never go to the Delaware Chancery Courts. That's really not a profitable area of argument for this, at least the last.
So just to be clear, and I know there's no bill in front of us, but let's just use the committee sub to House Bill 1875 as a starting point. Well, because I think it's important for us to distinguish between the two. So the committee sub to House Bill 1875 would have allowed what cases to be heard in front of
the first category were derivative cases, and the second group are basically disagreements between parties to organizations over contractual disputes of $10 million or more, and that was the two areas.
do we have any sort of breakdown? I don't see Megan anymore, but do we have any sort of breakdown as to how many cases in Texas for any given time period would have been sent to the business court in this case, or in those cases?
I've tried to delve into some of the statistical reports that are produced and was not able to get to that. I then made an effort to have one of our young people kind of just delve through the reported cases, on a Lexus or something, and that was not very helpful either. So I'm not sure that data exists anywhere. We have a lot of our members who actually, practice civil trial law in the larger law firms, and also many general counsels who pay them the millions of dollars of legal fee to try those cases, and they all nod their head yes when we say your cases get dragged, they're slow, they have a hard time getting through the system. We also have Government Code 23.101 and 102, which list off a whole set of important priority cases that should come ahead of commercial cases, and I believe that they do.
Okay. Yeah, Representative Schofield.
Mr. Chairman, more in response to you than to them, it would seem that data that would be impossible to get, because unless your contract or your corporate bylaws specifically require you to be in Texas, if what they're saying is true and that we are dissuading folks from filing here, you'd file in a different venue. You'd file in New York or Delaware if what they are proposing is correct, that the system here where you got to sit in line behind a bunch of other stuff and you're going before judges that don't know the subject matter. If all that's true, it's not a question of clogging up the Texas courts currently with cases. They wouldn't be here.
No, what I'm getting to is what I'd like to know is the cases that are currently, that have been filed in general jurisdiction courts in Texas that could have been filed in the business court. So they're not filed in other cases. They're filed here. They're in our general jurisdiction courts, but they could be in a business court.
What I'm saying is a lot of the cases that could be in our business courts may be right now litigated in New York and Delaware.
No, I understand, but that's not what I understand that, but that's not the number that I'm getting at, or that I'd like to see.
That number, as Mike said, is incredibly difficult to dig out. It's very difficult. Let me make one. Delaware actually they have the Chancery Court, and they also have a Court of Complex Commercial Litigation. So they've got actually two things. So they handle both equity and non-equity in their system for handling complex commercial cases. I should have handed this out earlier. TLR Foundation is published on this too, which, if I may, I'll
if you'll hand it to Representative Johnson, she'll pass it around.
Okay. And that's.
I will say, one of the interesting things about the TBLF is we actually have clients as part of our membership, whereas I don't think ABOTA has people who have been subjected to 10 jury trials as part of their membership, kind of, feeding their thoughts in all of this. But like the Association of Corporate Counsel, their national office representing more than 10,000 lawyers who work for America's corporations, have come out 100% in support of business courts. And they also, if you get a Chamber of Commerce presentation from the state of New York about coming to New York, the head of the ACC is on there saying business courts really are important to our companies, and we like them where we find them, and if you don't have one, you should get one.
Yeah.
And if I may respond to that,
feel free to.
The problem is, I think that we just don't show the need for that at this time. In addition to that, he's not talking about just setting up a business courts like, oh, we have a lot of family cases in Dallas because we're going to set up a separate family court for Dallas County. That's not what he's proposing. He's proposing a whole different court system, business courts layered on top of everything else. Currently, it's at $10 million. I don't know what the new bill is going to propose, but obviously there's a lot of cases that we handle that are tort and business, and our organization represents defendants as well. And so we're coming to you representing both defense lawyers and plaintiff lawyers with respect to the concern of setting up separate business courts where as currently written last year, the judges were appointed. They have different personnel. It's not described how they're being funded without causing additional costs to the taxpayers of Texas. These are all issues that we raised last year as well, but nothing in Mr. Parsons' paper or nothing that's being presented to this body clarifies or addresses any of those issues. Those are big issues. Funding's a
Well, I do want to, and maybe today's not the forum for this. Maybe we could do this in probably in a hearing next session. But the economic development, the business perspective, I think is one I'd like to really nail down on. In fact, I could be wrong, but I think that Representative Villalba's bill in 2015 actually went to the Business and Industry Committee and not to the Judiciary Committee.
That's correct.
And I don't remember if that bill was ever voted out of committee or how far it got. I actually don't even think it got to the House floor. But from a business development perspective, I did hear from two major employers in the state this past week that are incorporated in Delaware, but that would incorporate in Texas and move substantial operations to Texas if, in fact, we had a business court. So I imagine there are more businesses like that that we need to hear from. I think you probably need to hear from too. This isn't just a judicial issue. Reggie Smith, Representative Smith, you have a question.
Yes, thank you, Chairman. I'm not sure who to ask this to. Maybe Mr. Parsley. I cannot remember the bill that was proposed last session, Lee. Do you have a framework for how many courts, where they would be? Is there some kind of indication in the last expression of the bill about how it would be set up?
Yeah, the last session's bill set up a single business court of Texas that then had, I believe, 7 judges, and those judges the court would sit in Travis County officially, but the judges were really to go to local places to actually select juries and hold trials. So the last session's bill, and I wasn't aware of the data that was used, but I believe they had 7 judges on the court itself, but they sat individually. So it's more like a federal district court of Western District of Texas has multiple judges on it. It's the same concept.
And no more. They're specified that no more than 3 would sit in any one county. And so I think the anticipation was that they would be scattered around closer to some of the larger states, but also out in West Texas. There, to be at least 1 or 2 out there to handle cases from there.
So they would selection procedure in the bill.
It did. The bill called for appointments of those judges, but as Mike said, I think you have to distinguish between the concept of business courts and then how you pick the judges to go on those courts. Those would be, I think, 2 questions you would ask. And I'm sorry, Representative Smith, did I interrupt you?
No. I was just going to say, so these particular judges, you were saying how they would be scattered out across the state. They would have established courtrooms, they wouldn't just be essentially traveling to different places. They would have established courtrooms around the state. Is that your understanding?
Yeah, there is a provision for the state to provide an office for them to sit in, but in terms of one of the thoughts about these courts that has been borne out where they're in use now in places like Philadelphia and New York is that they use a lot of technology even before the pandemic. And the nature of these disputes lends itself to people appearing either on telephone or by video. And so that while they might be, you might have 2 in Houston and 2 in Dallas and 1 in Lubbock and 1 in Austin and 1 somewhere else, that most of the activity would go on without people having to travel at all. And that their offices would then, they would just access courtrooms through the state when they were needed to actually hold a session of court.
So with regard to the jurisdiction, I know what was relayed to us about what that bill proposed, but then with regard to venue, it would just be the general venue rules that apply to those types of cases or that we already have established.
Yes, that bill last session provided, I believe, that once the case was ready to be tried, then it was going to be tried in a county of proper venue. So some of the cases would have been filed originally in a county and then removed to the business court, and for trial they would go back, and that business court judge, then would have to go occupy a bench in the county from which the case was removed. Some cases would be filed in the business court to begin with, in which case it would be tried still in a county of proper venue. And so the idea always was that you were going to try the case in the county of proper venue under current Texas law, selecting a jury from that county.
Right, and so then the idea of the people of that county being able to sit in judgment on that case is still alive and well.
Yes, that's what was in last session's bill.
And that would be your intention for the next bill, Lee, is that right?
Yes, we believe that's really the way it ought to work, is that you should have a local county of proper venue trying the case.
Yeah. Thank you, Mr. Chairman. Thank you.
Thanks, Representative. Members, any other questions?
I have a question.
Chairman Dunn.
You know, I was sitting here thinking, since corporations are persons, are we traveling down a road where we have a system of jurisprudence that one for the rich and one for the poor?
You look like you're looking at me, Chairman Dutton, so.
I'm trying to get I was trying to get it really was.
Lee, he's asking you.
Go ahead.
I think but obviously that's a fairly philosophical question. I think that we're looking at this as a way for Texas to continue to lead the nation in economic development, because this big litigation exists, whether we would want it to or not, and whether you think these are big people versus little people, the litigation exists, and it is to some extent being conducted other places, like Representative Schofield pointed out. You know, these cases are going other places than to Texas, and the corporations are incorporating in other places than in Texas. And so the cases exist, they are going to exist, and it's just a matter of whether Texas wants to be like the other states and to try to create a mechanism for handling them.
But I may be wrong, Mr. Chairman, but I saw something about a poll recently that determined that Texas was out of all the 50 states, second highest ranking in terms of business. And so that would suggest that we may not have a problem in terms of attracting business. If we're already number 2 in business, so we're trying to get to number 1.
Well, in some scorecards we are number 1, but we're number 1 by intention. We are number 1 because this legislature has spent decades making Texas the best place in the nation to do business. We are the 10th largest economy in the world, and it's not by accident. And it's because this legislature has taken steps like this persistently, continually. Every session, we take more steps to make Texas continue to be the best spot on the planet to do business. And we really are the best spot on the planet to do business, I believe. And it's intentional. And this is another intentional step, we think, in that of many, many steps we've taken over the years.
But it seems to me that we've gotten to where we are without this.
Well, we'd gotten to some place before we started down the road of tort reform, and I mean, yes, but it is a step, and we are leading the nation in many aspects of business development and economic development. Texas is. It's just our opinion. There's no reason to stop doing the things that make Texas succeed, and this would be another step. As I said, it's not that we haven't gotten here. We've gotten here intentionally by taking a number of steps just like this, and we just think another step like this is what should be done rather than stopping. There's no reason to stop when you're ahead. I mean, the Dallas Cowboys don't go to the four corners offense when they're leading the game typically, right? They're continuing to try to score points, and they certainly are at Texas Tech University, which is my alma mater under Mike Leach. We never stop scoring points, right? I mean,
but you don't get any more high draft choices.
I think it would be helpful for the committee to hear from folks who don't often appear in front of the committee, from business leaders, entrepreneurs, from CEOs who this bill would in one way or another affect. If the business community, economically speaking here in Texas, is crying out for or has a wish list that includes a business court, I'd like to hear directly from them. They can write letters to the committee, they can meet with us in our districts, they can call our offices, but I think it's important for us to hear from these folks. So to the extent you can direct them to us, I welcome their feedback. Representative Johnson.
Thank you. One of the things that doesn't sit right with me with this is the concept that we would have a few specialty civil courts where the judges are not elected. I mean, our Texas Constitution provides for the election of our judges. It's similar to my comments earlier. And I think we have some significant constitutional issues as to whether or not the appointment of business court judges is constitutional. Because, I mean, I was just looking at it right here. It says, the Texas Constitution provides the district and appellate judges will be chosen by popular election. You know, and so I think also because people, again, have the right in our state, one of the state reasons why our state, I think, to your point, Chairman Dutton, is thriving in business. We just discussed we're having a record surplus in our state budget because our economy is doing well. I don't think this argument that business is suffering, hence we have to rehaul our judicial system, has merit. But we do have constitutional protections for how our judiciary functions. And one of the key constitutional protections in Texas is the election of judges and not by appointment. And I think, you know, we had a committee last session that went around the state about appointment of judges, and that bill died because people want to be able to elect their judges. And then, so how would it work? What if one party wants to submit to a business court, but the other party objects to that venue, and they want to have their business dispute heard in their local community by their local judge because maybe they don't want to go to wherever, or they want to have a stability of their judicial environment? How are those rights to be preserved and protected? It seems to me like our judicial system is working well. We don't have a system where we have our system is so clogged and backlogged that we need to create at a whole nother level of expense and access. I'd rather see us fund the district courts that we have, to your point, Mr. Chairman, earlier, and give our district judges a pay raise and put those resources into the district system that we already have established. But I had a lot of concerns about not electing the judges for this court. I don't think it's...
I know that there was a provision in the committee sub to House Bill 1875 dealing with the potential unconstitutionality of the judges. Is that, I think the Supreme Court, if it was found to be unconstitutional, would then appoint visiting judges?
That was identified as, you know, a quick way to kind of get the court propped up and moving if there was a challenge, so that it would go directly to the Supreme Court. But one of the authors of the bill, pointed out in our study for this that there's a case called Jordan versus Crudgington, decided in 1950, interpreting and confirming that Article 5, Section 1 of the Constitution means what it says, which it says that the legislature may establish such other courts as it may deem necessary and prescribe the jurisdiction and organization thereof, and may conform the jurisdiction of the district and other inferior courts around it to what it sets up. And so I think they contemplate, okay, the district courts are inviolate, they are elected judges, they're constitutionally established, but the idea that there might be some areas where the same public interest, where it isn't, this is kind of a court for Goliath versus Goliath, not David versus Goliath. And when Goliath and Goliath are fighting with each other, and basically all of our retirement funds depend on whether they can make money or not, and whether they spend it all on litigation, I think we all want them to spend less on litigation than they are now. And this is one way to do it. And the Goliaths, pretty much, I think, when the Association of Corporate Counsel all stand up as one and say this is a good thing for our corporations. They're saying it's a good thing for our bottom line, it's a good thing for Texas taxes, it's a good thing for Texas citizens.
Yeah, but the issues are different. There's the issue of the establishment of the court on the one hand, and then the secondary issue is, well, how are the judges selected? And your argument was whether or not the court should exist, not whether or not the judges should stand election by the people of the citizens of the state of Texas, which our Constitution requires. And so I think, there's two issues there. One is the merits of a secondary level of court system, but I'm really keyed in on, well, how are those judges selected? And I strongly believe that our Constitution requires that they stand election, because essentially they're serving the functions of a district judge.
And I believe in the Jordan Crutchington case that was one of the issues there, because they had some people in the courts that were not elected under the constitutional structure. And the court said, if the legislature wants to create a smaller, separate court to hear some specialty issue, it can decide how those judges are selected. Now, again, I think the issue of you like to see judges elected. Then there's the question of should they be elected in a partisan election or non-partisan. There's a whole series of discussions to be had there. I think the feeling was because these issues that these courts will hear are so nonpartisan that if there was an election, it would be maybe appropriate to consider a nonpartisan election process for that.
On election of judges, just to kind of make sure we're all operating on the same page, the Constitution says, as Mike has noted, that the legislature may create other courts. And it doesn't say may create other courts and those judges must be elected. It just says you guys can create other courts. It says that district judges have to be elected, Court of Appeals judges have to be elected. So each individual section of the Constitution, if it's a section about district judges, it says these district judges have to be elected. But family law masters, which you probably know about, do the job of district judges, but they are not elected. They are selected by the local district judges. So family law masters out there today are an appointed judge that do the job of a district judge.
A family law master is not anywhere close to the same thing, because it's an administrative function, a master position that serves the district judge, and the district judge ultimately signs off on any final orders. And that's not an accurate example of how masters work.
Right now the State Office of Administrative Hearings is an appointed body. Municipal court judges who decide how long you stay in jail when you get picked up on the streets being drunk are appointed. So we have a combination. It is just not correct to say that our judiciary is wholly elected. It's not. It has parts that are elected and parts that are not elected. And as we understand the Constitution, that's possible to do. Now, again, that's a different question than I accept that your view that if the legislature were to create business courts, it would want to make those judges elected judges. I don't have a quibble with that. That's a perfectly valid policy position that I don't quibble with. I will just say that we do have a system that has some elected judges and some appointed judges in it today in Texas. And that's all I'm trying to make sure that we're, in terms of our base, we do have a system that's a combination. And we appoint a lot of judges, frankly, to fill vacancies for periods of time. So we just have a little bit more of a combination system than we all collectively think oftentimes that we do.
Okay, just one different comments, Representative Leach. First is that this is being promoted as improving the economy of Texas. And there's nothing to show that having business courts will improve the economy of Texas. I could bring in a line of CEOs that says, yes, I would prefer to have a separate court hear all the issues that I'm the plaintiff on, or all the issues that I'm the defendant on, et cetera. But that doesn't mean it would improve the business economy of Texas. So those are two different things that aren't tracking well. That just means that's what they would prefer. That doesn't mean that's why they moved here. Elon Musk did not say, I would have moved here sooner if we'd had a business court in Texas. Well, I don't know that he would say that or not.
But what if because I understand what you're saying, but I do think that there are some business owners and CEOs out there who would say, give me a chance to share my story, and I will. And maybe not all of them, but some of them certainly might.
Some of them might. And some of them may say, I want to be sued in my county where I live, or I want to make sure that I only sue in my county where I live. And if we're going to go there, then all we're really talking about is if it's like everything stays the same except for we have the governor make these appointments, then that's more party dependent, depending on who's in office at the time. And, the longer you live here in Texas, that flip-flops back and forth. In my 30-plus year legal career, we've seen all sides of red and blue. So that definitely changes. It just doesn't mean that that's going to necessarily improve the Texas economy. What we do know is that setting up an entire different court system just for businesses, however that's defined at the time. And those of us who practice law long enough know that definition changes. Will cost Texas taxpayers, period. The filing fee would have to be so enormous which then again would lead only to specialty courts for specialty people. So say if I am a smaller company, but I've got a $10 million case against your company, but I can't afford to pay the filing fee because it's set so large so that we don't tax the taxpayers of Texas. I mean, this is going to be an issue.
There wasn't a filing fee set in the bill, was there? It gave the Supreme Court.
It didn't, but one of the criticisms of the bill, Mr. Chairman, is that it cannot be self-funded unless the filing fees are enormous. Otherwise, it's going to come out of the taxpayers, and you're just setting up yet another layer for only specialty people, specialty companies.
The fiscal note, I believe, that was attached to it showed about a $6 million a year out-of-pocket expenditure with no assumptions about any fees really being paid in. I'm not enough of a statistical wonk of our court system to know what percentage of our court costs are paid by fees, but I understand it's 20% or less at the end of the day, because so many of our litigants can't afford it. By focusing on businesses that have enough money to have a $10 million problem, you're dealing with people that can actually pay, even if. But I don't think we've ever promoted this as a money-making project for the state.
And yet, is that even fair?
Yeah, Representative Middleton.
Yeah. Thank you, Chairman.
Sorry,
I guess for Lee, or it's probably for him. So do y'all think this, it's hard to speculate, it's not created yet, but would you primarily think it'd be contractual disputes, most likely would flow through this business court, district, and appeals?
Right. Big contract fights and shareholder derivative things. Yes, that's what you're talking about largely.
So would you? I'm sorry to jump in here, but in the contractual venue provisions or dispute resolution, provisions in the contract, would it specify the business court as the forum of?
Many times, people will specify, like the commercial division of the state of New York in Manhattan Island is in an express venue provision. Obviously, no contract is going to be written specifying this court until it exists.
Right.
So it'll be a progressive thing over time.
So I guess my second point for that was, I think a lot more businesses settle contractual disputes than they want to because of the time with district court and court of appeals. And time is money, and you got to calculate what's that going to cost. We're not happy with this, but that's what we're going to do. And $10 million is, you ask for the moon when you sue. There's going to be a lot of small businesses that this would apply to with $10 million. So it's just good for public policy if they feel like they could get to justice faster, because that calculation becomes something more manageable where the timeline gets shorter for the district court and the court of appeals, whereas they say, yeah, let's go to trial. We weren't going to do that, but this docket's pretty short. We think we can get there pretty quickly. We don't have to wait too long. And, we know with small businesses, if it's $10 million, they don't have a legal department. They're the CEO, the person running it, whatever their title is, the business shuts down to handle this litigation. So the faster it's resolved, the sooner they can get back to doing what they do and creating jobs and growing their business. So I think maybe we sort of missed that a little bit today, where he talked about Twitter and some of the big companies. I think it would actually help some of the small and medium-sized businesses most, because something that maybe doesn't get talked about a lot is there are some companies out there that run the numbers on breaching their contracts. They do, and they get to the point of where they know just at the line where it's not quite worth it for the other party to sue and bring it to trial. And they know what that is, and they know there'll be a settlement. And they build that into how they operate. And it's wrong. I don't like it, but that's what happens. And I think this would partly resolve part of that. So, this is a good thing for small businesses in our state. I think it allows a resolution to happen more quickly, because time is the most valuable commodity. And this would allow them to spend less time on any contract dispute that they have.
Most of these states provide annual reports of the cases that come through their business courts, and they put clocks on them. And like I was just reading a Pennsylvania report, and I think the Philadelphia court, their business court in there, said that their cases tended to, more than 80% of them were resolved in less than 12 months. And I remember reading one from Wisconsin that said, the average time to collect a debt in in Wisconsin's regular civil system was something over 20 months, 24 months. And after these courts came in, it dropped down to like 12 or 13 months. And so there is one of the efficiency things that you get here is a much more rapid decisional process.
And don't we want to look at that compared to the data that we have now for our counties? I would think we would want to have that data to see how long it does take for any business dispute. I believe we can parcel out between, and I know we can in our district court, I'm assuming other district courts can, between personal injury cases and big business cases, just to see how many there are.
That's if y'all can get us whatever data you want, our committee will.
It's almost you want a satisfaction survey on, did you want to settle that? Would you have not settled it if you could have been in a venue or a court system that would have had a good chance? I mean, you can't promise timelines, obviously, but a better chance at a faster resolution.
Mm-hmm.
Would you have taken that to resolution, in a courtroom, in a business court, and perhaps to the Business Court of Appeals?
Time is the enemy of business on these litigation matters. When I was a full-time practicing lawyer, which I did for more than 25 years, my clients wanted to be able to resolve issues quickly and fairly, right? Many times they just needed an answer, right? Certainty was part of what they were getting to. They need to get an answer to resolve that fight with whoever it is they're in a fight with. And so, and they need that answer more quickly than later, right? And the problem, they were very frustrated, and we'd end up on appeal. I literally was involved for a long time in Texas's oldest untried lawsuits. We were in litigation in Texas for 25 years, literally, and that's completely true. We finally settled it, never got the case to trial. So it's painful and it's harmful to business, and you can't operate like that. And so anything that helps these cases get a resolution and quickly is important to business. It just is.
Chairman Dunn. Sorry, Representative.
I was just going to add, lawyers are going to take advantage of whatever system we create, and it depends on who's paying you is how you resolve it. And so if it's to their benefit to stretch it out over a period of time, irrespective of what we do in this bill, it's going to get stretched out over a period of time.
Well, I will push back on that. I practiced law for 25 years. I tried not to be ever self-motivated. I can't say that I wasn't, but I tried to do what was in the best interest of my client, and I believe many, many lawyers in this state do that. Maybe not all. We've got some bad apples, but I think if lawyers have the opportunity to do the right thing, and they've got a client that's saying, I need you to do the right thing, I think more often than not, they're going to.
Well, yeah, I don't disagree with that. I don't think what you said is in disagreement with what I said either, because they're going to do what their clients desire, and if the client desires to extend this out over a period of time, it'll get done. So that's my only comment, Mr. Chairman.
All right. Members, any other questions from the panel? Okay. Thank you all for
Thank you.
today.